Why are people continuing to have children and they don't have their life together? A gun is pulled on the guy. You want his gold chain. And in the steps, he said you even brought the equipment to determine the clarity of the gold chain. And he did tell the guy, hey, no, I'm not going to shoot you, but I will beat you with this gun. So I don't know if anybody wants to address those for the court, because I find it very concerning as far as it relates to public safety. Why are people continuing to have children and they don't have their life together?
I can't answer that for you, Judge.
And then number two, I will say this, with regards to this case, nobody has clean hands. It just depends on whether or not the public will be safe with his having probation. And based upon what I'm reading in the stipulations, I have some issues with giving him probation, and maybe somebody can alleviate my concerns, maybe not. Here are my issues. You have the complainant who meets the mother of your child, and they're supposed to be meeting up some hotel to engage in certain intimacies in exchange for funds. And according to the stipulations, this was all planned out for you to come in and take money. And a gun is pulled on the guy. You want his gold chain. And in the steps, he said you even brought the equipment to determine the clarity of the gold chain. And he did tell the guy, hey, no, I'm not going to shoot you, but I will beat you with this gun. So I don't know if anybody wants to address those for the court, because I find it very concerning as far as it relates to public safety. And I don't know if anyone is able to address those concerns. And I know that the co-defendant, the mother of your children, is in Arkansas. She ended up in probation, and I know, but for her, this probably would have never happened, because if she wouldn't have agreed to meet up with him at a hotel, to have intimacies with him instead of you all getting a real job and taking care of the children that y'all decided to birth into this world, we wouldn't be here. I solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God.
I do.
All right, you can lower your hand, state your name for the record.
My name is Carl Robinson.
All right, you may proceed.
Mr. Robinson, can you tell the court why you think you should get deferred adjudication in this case?
Of course. I could mitigate a couple vast scope of factors, but specifically what I would like to proclaim is what it is. Let me start in this minute.
Oh, take your time. You don't have to rush through it.
When individuals promulgate that they have changed, it is usually that of futuristic, that I'm going to change and I'm going to do this to change it. And what I proclamate is that I have, it's more than external, it's that of internal. It's that of a genuine disappreciation for the nescience that transpires within the masses.
Do you want to take a moment to collect your thoughts?
Yeah.
If you want to do that, we can do that. Here's the thing. I want you to present the information to me that you want to present to me and the way that you want to present it. So I'm not going anywhere. I'll be here. If you need a moment to collect your thoughts with your attorney, I'm fine with you doing that, okay?
If you want to.
Yeah. So let me give him a chance to collect his thoughts with your attorney. Then you can come back, okay? Okay. All right, who's next?
I have Keith Mosley Thompson.
Keith Mosley Thompson. Well, is she? Is that?
I
the-
have to swear in for the interpreter.
All right, if y'all would step back, let me take up the interpreter first because they can only be here for a little bit.
Okay,
So-
so Judge, they gave me a plea for the interpreter and I just got to it right now. I have to print out documents.
Yeah, I was gonna let you know that I was here. And
Thank
then
you.
also another attorney, incident.
Okay. All right, what does need to happen with your person that you have an interpreter for?
Speak Spanish.
No, I mean, what are you approaching for?
We have an MTR, we're gonna discuss with the client.
Okay, all right. So if you'll do that, then I'll take up Thompson. All right, let's go. We're juggling balls today.
Okay.
They're there. Yeah.
Carl Robinson, this is Michael stuff all again.
All right, is there a application?
Yes, Your Honor. Are we missing them in both?
Yeah. All right, the court is calling 2025 CR 013364, State versus Keith Thompson. Can I have parties announced?
State.
Eric DeWalt, and I represent Mr. Keith Thompson.
And are you Mr. Thompson? All right, I'm gonna need you to speak up so I can hear and the court reporter can hear.
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Thompson, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am, I did.
All right, did you review the true bill of indictment with your attorney? Did you understand it? Also, do you waive the reading?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive count one and proceed solely on count two.
Any objection?
No, Your Honor.
Mr. Thompson, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
All right, you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call them the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Thompson, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, state is proceeding on count 2. Punishment is to be assessed at 6 years in the prison. There's a $1,200 fine. State recommends community supervision. They're taking in consideration 2025 CR 013362 and 2026 PF 13998. Did you understand that to be the plea?
Yes, ma'am.
Defense and state?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years, that there be a TAP evaluation, 120 hours of community service restitution, regular random UAs, DOEP, and a referral to felony drug court. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, Not guilty or no contest?
No contest.
All right, and for the record, that's to count two. State any evidence.
Yes, Your Honor, state offer states exhibit one in all attachments.
No objection, Judge. It's admitted, Your Honor. We've reviewed it.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
Just, Your Honor, he's been upfront and honest with me so far. He understands the plea bargain and asks that you follow the state's recommendation, please.
All right, this location you were residing, do you know the person Paul Ibanez?
No, no,
Destiny Carrera,
no, ma'am.
Aiden Aldaca, Gabriel Lar.
No, yes.
Okay, how do you know Gabriel?
He's helping me get my mom out of jail on bond.
Okay, your mom in custody?
She was at the time, yes, on, it was failure, child abandonment for my little sister about maybe 35 years ago. When my stepdad split up, she sent to live with her grandma, they didn't let her see her, and she got hit with child abandonment. So it came back last year, or the year before, and he was gonna help me get her out because I couldn't, because I never had him, so I couldn't get her out of jail, and he couldn't.
Okay, and how long have you been using? And when did it start, really?
When did it start? When I was 28, when I lost my job. I mean, for a while, I don't got the lab tech. I was working for trials. And someone just introduced me to it, and I tried it, and it became there.
Yeah, sometimes that's the way it happens. Somebody introduces you to it. I really hope that things will change in regards to that. Because sometimes you take it once and then you're hooked.
I just thought I never rested. I quit it already.
So do you have any children?
No.
So if you're released, who would you be living with?
My roommate, George Satcher, who's been pretty much my only friend through this whole process, except when I was using, he was against that. That's why I got kicked out of there.
Okay.
And he was forced to straighten up. As a kind of a friend and landlord, right? Yeah.
All right, this is what the court is going to do. There's a $1,200 fine that will be probated. Sentence you to 6 years in the prison, suspended and probated for 5 years. Regular reporting by Zoom or in person. You need me to stop, Cindy?
No.
You need a cough drop?
I've got one.
You need any water?
I do got some water. Let me get that.
Mhm.
Okay.
I think they're gonna find out that maybe there's something wrong with this building. Regular random UAs. There's gonna be a referral to felony drug court. Now, I can tell you, I'm gonna have that done in custody, but felony drug court will be able to see you this week. So I'm gonna get it today. I'm gonna sign it today. They'll see you this week. So referral to felony drug court in custody, a TAP evaluation out of custody, follow Rex. If it recommends inpatient treatment, we'll start with intensive outpatient treatment. Take in consideration 2025 CR 013362 and 2026 PF 13998. There's to be no contact with the following parties. Paul Ibanez, YBANEZ. Destiny Carrero. Scherer, Scherrer. Aiden Aldaco, Aldaco. Gabriel Laura. There's to be no residing in households with minors. No unsupervised contact with minors. Field visits 1 time per month for 8 months. 120 hours of community service restitution. The court will deduct 1 hour for every sober support meeting that's completed. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Right.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what that is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So here's the thing. I know you're anxious to get out of jail, get back on with your life. You made promises to yourself that I'm never going to use again. I'm not going to do this again. You need to hold on to that and don't get caught in this backsliding, because if you are on the path where you're doing sober support meetings, if you end up missing one, then you'll look up and you will have missed 30. All right. So don't say, you know what, I'll just do 2 the next day, or I'll just do that, because then you look up and you're off the path, and you need to remain on the path. Otherwise, you're not going to be able to get a control of your addictions. Okay. All right. Good luck to you. You're welcome.
Thank you, Your Honor, for our consideration. May we be excused?
Yes.
Appreciate everything.
You're welcome.
On the first row, sir, have a seat in the first row.
Reset whenever you're ready.
Do you all have the person who has the interpreter?
There's still possible.
Oh, well.
No, I mean for the plea.
Which one, please?
Joseph.
Which one?
Joseph.
No, he needs an interpreter as well for the reason.
No, do we have the interpreter for the plea ready? That's what I want to know. Is the plea ready?
Not yet.
Okay. Michael, you ready?
Yes, we are.
All right.
'Cause we don't need an interpreter.
Yes, come on down. Lauren, we're going to go back on the record. Are you ready on Carl Robinson? All right, we're back on the record in 2025 CR 012572-02. Carl Michael Robinson. Can I have parties reannounced?
Michael DeLeon for Mr. Robinson.
All right, Mr. Robinson, you're still under oath, and did you have a chance to think about what you wanted to tell the court?
I did.
All right, do you need any more time?
No, no.
All right, Mr. DeLeon, you may proceed.
All right. Can you tell the court why you think you should get deferred adjudication?
Certainly, requesting a chance of external rehabilitation. That's it. Have an opportunity to be there for my children, all the women depended on me, and then, you know, and evolve. You know, it is kind of limited, if I may, to evolve in such circumstances. Yeah. I have them, and did, but simply asking that of you understand that I have a very small record, if not minimal, you know, that of a misdemeanor, and I just feel as if I would proclaim that I qualify and deserve such chance to prove myself to myself and to my family, then again to be there for my children.
Mr. Robinson, let me ask you this. Do you feel like you can meet the qualification, do everything probation tells you to do if you're placed on probation?
Certainly,
And you want to have, you have an infant, you have an 18-month-old child, you want to take care of them, work, be responsible for them, help provide for them.
yes,
Okay, you said previously, you said that you're only, I think, the only adjudication of a crime is a fail to ID misdemeanor, correct?
correct, sir.
Okay, you've never been convicted of a felony in this state or any other.
Correct.
Okay, and if the court places you on deferred adjudication, you and I have had this discussion. If you're placed on deferred and you do not meet the requirements of your deferred adjudication, you can be brought back to court and face anywhere between 2 up to 20 years in prison. Do you understand that?
Yes, sir.
So if the court gives you that one chance, you understand that if you messed it up, you could be facing 20 years, correct?
Completely comprehensive.
Okay. Anything else you want the court to know?
I will evolve.
When you say you will evolve, does that mean you're gonna become a better person? And
In retrospect, in knowledge and character, and in retrospect, so I will evolve generally. I have evolved therefrom, but I am subject to inevitable evolution.
that's all I have for you, sir. I'll pass the witness.
Hello, Mr. Robinson. My name is Lauren Espinoza and I represent the state. I just have a few questions for you, okay?
Yes, ma'am.
Okay, so you told the PSI officer you came to San Antonio in August of 2025, correct?
That is correct.
Do you remember the day?
I do not, and actually, that is incorrect. I said I came in July, a couple weeks before. If you were to see the PSI, I said I was sick.
So would it surprise you to learn that in the PSI narrative, it says August? So is that incorrect then, I guess, is the question?
I guess that was improperly documented. I got incarcerated on August 9th.
Okay,
Or August 8th, one of those days. And yes, I was here a couple weeks before, almost a month. So July is
okay, so you came to San Antonio in July then,
somewhere
Okay.
around that time.
and you were living with your mom for a bit, right?
Correct.
And then where were you living after you stopped residing with your mom?
I was residing hotel to hotel.
Do you recall the names of the hotels?
I do not.
Did the hotel by the name of Best Value Inn sound familiar?
No,
Okay, so approximately August 2nd, 2025, you weren't staying at the Best Value Inn with Miss Santiago?
I do not recall.
Would it surprise you to learn that she rented 2 hotel rooms at that hotel?
It would.
It would surprise you. So it would also be surprising to you that you were seen on surveillance video with her going from room 222 to room 218.
Well, I would have to. I don't know what exact hotel this is, so I don't know exactly what you're specifying. But I understand that this is the whole step to this specific litigation. You're not talking about this transpired.
It's an incident on August 2nd.
Right, this is not the date of August 8th, therefore it is
Right, but
unsubstantial within
you're-
objectivity, correct?
But you're aware that you were alleged to be a suspect of a robbery of a similar nature on August 2nd
Alright.
with Miss Santiago.
Judge, I'm gonna object to the question at this point for the purposes of sentencing, only because he has pled no contest to the substantiated facts that are in the PSI. I don't see the relevance of the questioning for the purposes of sentencing.
Your Honor, the offense report regarding him being a suspect on August 2nd was included in the stipulations, and it does show that he had a firearm and was participating in the same not continuous, but the same course of conduct as the instant offense here, August 9th, 2025.
All right, so here's my question. The questions that you are asking him to commit to, are those for a different offense or this offense?
It's for an incident on August 2nd that mirrors the exact fact pattern as the August 9th offense that he pled no contest to.
It's not charged with any type of crime for August 2nd, so I don't find that relevant. Plus, this is stipulations. He has stipulated to this, Your Honor.
All right. With regards to relevancy, that's going to be overruled. However, I don't know if your client is intending to exercise any rights related to that question. Oh,
Okay, so the instant offense here, August 9th, 2025. Do you recall being at a Best Western Plus?
This is accurate
Yeah, on IH10, right? And you were there with whom?
with the mother of my children, Akira Santiago.
Okay, and do you recall being inside the hotel room when the alleged individual complainant came into the room?
Yes,
Okay, now I want to ask you, we found out a little bit about you, right? You have 2 children. Were you thinking of your children on August 9th, 2025?
Object argumentative, Your Honor.
overrule.
You can answer the question.
was I thinking of my children on this specific date of said transpirance was the question. Yes,
Okay, and did you consider how your actions might affect your children? Or I guess child, you had a 10-month-old.
I could have pondered furthermore.
Okay, so it's your testimony to, or I guess, let me retract that. You are asking the court to grant deferred adjudication, correct?
Correct, ma'am.
What steps are you going to take to better yourself? Or what steps have you taken?
It is an internal switch in which I probably is just that of not partaking in ignorance, if I may, subjecting myself to studies, sophisticating my characteristic rather than again subjecting to the nescience. That of we have 8 hours to be out within this predicament I am subjected to. And I have completely inverted my schedule just to stay up, to study all night, and divert from things that are irrelevant. Such things those are substantial steps, if you ask me. You know, that of studying, that of planning.
Okay, so if you were to be granted probation, you plan to reside with your mother, correct?
Correct,
Which is someone you were living with before, correct?
correct,
And you plan to co-parent with Miss Santiago, correct?
correct.
So how can you be sure you're not going to revert to old habits?
Well, thy will shall be done, and my will is certainly not retroactive transpirances.
And Mr. Robinson, how did you obtain the firearm allegedly used in this offense?
Object to relevance at this point, Judge. It's part of the stipulations.
All right, that will be overruled.
That's the question.
Private cell. That is state.
Private sale?
Yes, a private cell.
Was that in here or in Arkansas?
That was in Texas.
No further questions, Judge.
No further questions, Judge.
All right, I have some questions.
Okay.
And maybe the attorneys can ask it. Number one is, so anybody want to address my
Judge.
concerns or issues?
Judge, I will address with essentially my closing argument is that Mr. Robinson's 21 years old. Young men make stupid choices. And stupid choices were made in this particular case. However, he has never been convicted of a felony before. He's been convicted of fail to ID one time in some other jurisdiction. He wants that opportunity for deferred adjudication, Your Honor, to prove himself. If he messes up, he is facing 20 years. That will ensure the community that of public safety in this particular case. I don't know if does his brother still live in Arkansas?
No, my mom
Sure.
stays here.
Okay. Regardless, Judge, with a co-defendant who got 5 years, a complainant who got his gold chain back, a complainant who was outdoing, illicit things. Regardless, he wants that opportunity for deferred adjudication. If he messes up, he's gonna be back here. He's gonna get 20 years, up to 20 years under a deferred adjudication. We want that opportunity for him. Like most people, 21-year-old man placed in this position by themselves because of poor choices. He knows that, he gets slapped in the face with the reality of the criminal justice system. He has that one more opportunity, Your Honor, if the court provides him with deferred adjudication, provides him that opportunity to do right, to change his life around. If he doesn't, then he's facing up to 20 years at that point. So we'd ask the court to consider the fact that he has not been adjudicated on any other cases. And in this particular case, even when in the steps, he says, I'm not gonna shoot you, but,
I'll beat you.
I'm paraphrasing. And,
I mean, what are you shaking your head for? That's what's in the stipulations.
That is what the witness proclamated, Ms. Boyd, but that is not.
All right, this is what I'm going to ask you to do for me. Stop using words that have more than 3 syllables that are in no way related to the questions that are being asked of you. So here's the thing. What's in the stipulation is what I go by, because stipulated means, everybody agrees. If this person were to come into court to testify, they're going to say exactly what's in the stipulation. That's when people sign off on this, that's what they're saying. They're saying, you know what? If this witness comes in, they're going to say exactly what's in the stipulations. And when I review the stipulations, I'm viewing it to see whether the evidence is sufficient enough to find somebody guilty beyond a reasonable doubt, right? That's what the stipulations are. And obviously we're here at sentencing, so I have deemed that there's enough evidence that has been presented by the state through way of stipulation for you to be found guilty. So that's what's in the stips that I read. If that's not what I read in the stips, somebody correct me. I'm not going to take offense.
That is what is in the stipulation.
All right.
nothing further, Judge.
State.
Your Honor, we ask that you deny the application for deferred adjudication sentenced to a cap of 6 years in the prison. Defense counsel points to the co-defendant getting 5 years deferred adjudication. However, it was Mr. Robinson that had the firearm and held the complainant at gunpoint. Further, the state would assert that Mr. Robinson does pose a potential risk of flight. Based on the PSI, he does have the 3 fail to appears in Arkansas. For June and July of 2025, which were dates prior to this and shortly before Mr. Robinson did show up in Texas, as he told the court. It's actually July of 2025, not August. So he does pose that risk of flight, and I don't think he would be a good candidate for deferred adjudication. He poses a risk to the community, Judge. We can't have people in our community going around holding people at gunpoint instead of getting jobs to financially support themselves in that way. So for that, we'd ask that you deny his application.
And lastly, Judge, on the court dates in Arkansas in July or wherever, it's all hearsay. We don't know exactly when those court dates are. We don't know anything about whether he was supposed to appear or not appear. If there's a non-appearance docket, we know nothing about that. So a little nitpicky on the state's interpretation of those dates, but the main big picture is this young man has never been convicted of a felony before. We're asking for deferred adjudication, Your Honor.
All right. So this is what I can tell everybody. He's going to be convicted of a felony today. So I'm not going to grant your application for deferred adjudication. Now, whether or not I give you probation or not, that's something I still need to think about. So I'm going to find him guilty. And then, counsel, you're available to come back tomorrow by Zoom?
I'll be here.
All right,
I'll be
you'll
in
be
the
here?
courtroom on a different matter, Your Honor.
All right, so the court is going to find you guilty. I'm not going to grant your application for deferred adjudication. And I'll come back tomorrow and let you know whether or not I'll grant probation.
Thank you, Your Honor.
Thank you.
Thank you.
All right, Rhonda. He's to come back tomorrow. All right, who is here with the interpreter? Are we ready? Thank you. Is this an application?
No, it is not. It's a tour.
All right, Joseph?
It is a probation.
Okay,
It's a reduction to misdemeanor.
okay. Hello. All right, court is calling 2025 CR 015212, State versus Yetson Joseph. Could I have parties announced?
Sandra Gonzalez for the state.
Brenda La Paz for Ms. Joseph.
And are you Miss Joseph? Yes. All right, we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Lupita Buitron.
All right, counsel, do you speak Spanish?
Yes, Your Honor.
And do you speak it fluently?
Yes, Your Honor.
And were you able to review the documents that are in English with your client in Spanish?
Yes, Your Honor.
Ms. Joseph, were the documents explained to you in Spanish?
Yes.
All right, counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Joseph, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Lesser included, driving while intoxicated, 0.15 or above.
No objection, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it?
Yes.
All right. The state is proceeding on the lesser included offense of DWI as a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and is legally sane at the time of the offense?
Yes, Your Honor.
Ms. Joseph, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No. No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a citizen, you could be deported, denied naturalization, and re-entry by entering into this plea. Do you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, state is proceeding on the lesser included offense. They're asking that your punishment be assessed at 1 year in the Bear County Jail, $800 fine, probated. State recommends community supervision. Did you understand that to be your plea?
Yes.
State?
Yes, Your Honor, we don't proceed to the one.
No, is that the plea?
I'm sorry, yes.
Defense?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And sign it in both places?
Yes.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No motion, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 80 hours of community service restitution, ignition interlock for half the term, VIP live, DWI education course, driver's license suspension for half the term, and parenting class. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the lesser included offense, how do you plead guilty, not guilty, or no contest?
Memorable. No contest.
State any evidence.
You offer states exhibit one of the attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both places?
I'm sorry, the interpreter have a repeat.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Part of our negotiations, she was to complete the DW education and an impact panel prior to our taking this. So she has that ready to show to probation. The rest of it, I think she is manageable. I did discuss this with the state this morning or today. She is in a study, one of those like monitor you for different things. That's going to start tomorrow. There's only going to be 2 instances where she's going to be in a facility for 10 days. One of those happens to be tomorrow. I discussed that with the state. I think she'll have her phone with her. I don't think anything should interfere with that. Oh, we did, Your Honor, talk about, she does have ignition lock on her phone right now. We did talk about the possibility of the track watch, which is new to me. It's something that's an alternative, just so she doesn't miss any load times if she's in one of those places.
Okay. All right. The court is going to sentence you to 1 year in the Bear County Jail, suspended and probated for 2 years, regular reporting by Zoom or in person, regular random UAs, $800 fine, probated, 80 hours of community service restitution. I'm going to order parenting classes. 40 hours will be deducted upon completion of parenting classes. 1 hour for every sober support meeting completed will be deducted. VIP live, DWI education course, ignition interlock for half the term or other portable device. There's to be no driving without ignition interlock. TAP evaluation out of custody. Follow recommendations. If TAP recommends inpatient treatment, start with intensive outpatient treatment. Field visits 1 time per month for 8 months. Proof of employment within 45 days, no employment as a home health care provider or with minors. Probation, is there anything else?
What about the driver's license?
Oh, thank you. There is to be 1 year. Are you all asking for a year driver's license suspension?
It was half the term, Your Honor.
That's a year.
Well, on that note, Your Honor, she did have a 3-month suspension, so that she should be giving credit for that, and then I will prepare an occupational license to bring that back to the.
All right. I'm not going to give credit for that. There'll be a 1 year driver's license suspension. Probation, anything else?
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, and I'm assuming I don't need to go over with you what could have happened if you're intoxicated, you're driving with a child in the car, anything can go wrong. You understand? So what you need to do is you need to start, well, one, since you're on probation, you're not allowed to drink at all while you're on probation. But after this probation is completed, don't drink. You understand? All right, good luck to you.
Thank you, Your Honor. Maybe she.
You're welcome. Yes. Who's next? Who else needs the interpreter?
I didn't,
All right, and who is your case?
$7. We're ready.
All right, is this a motion to revoke?
It is.
No, I don't have Diamond Garza.
I do not have Diamond Garza's Spirit Church. BC.
Sort of feel.
First,
There it is.
did I?
All right, Diamond Garza. Oh, it's Garcia, Diamond Garcia. Hello. All right, the court is calling 2024 CR 008365 State versus Diamond Ashley Garza. I'm sorry, Garcia.
Sorry.
Yeah. Can I have, now that's in my head, Kelly.
I know.
All right, can I have parties announced for the record?
Ms. Gonzalez for the state.
And Kelly Piddle for Miss Garcia.
And are you Miss Garcia?
Yes, ma'am.
All right, we have an interpreter and you're still under oath to the interpreter, but would you state your name for the record?
Lupita Buitron.
All right. Mr. Piddle, do you speak Spanish fluently?
I don't, Judge.
All right, and have you used the interpreter to interpret all of the documents?
We have.
All right. Ms. Garcia, all of the documents are in English. Will those documents explain to you in Spanish?
Yes, ma'am.
Well, so here's the thing.
Gotta speak Spanish.
I don't know a lot of Spanish, but I know yes, ma'am is not how you say it in Spanish. So you're either going to speak in Spanish or not. So do you prefer speaking in Spanish or English?
I'd rather speak English.
All right. There we go.
Thank you, Your Honor.
Thank you.
Okay.
See, you have to ask, right?
Yes, ma'am.
All right. Did you review the motion to enter adjudication of guilt with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Diamond Ashley Garcia who was placed on deferred adjudication in 2024 CR 008365 for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams on September 26, 2024 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
We're here on a violation of condition number 4 in Bexar County, Texas. The defendant Diamond Ashley Garcia did then and there fail to report to the supervision officer as directed for the months of September 2025 and October 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
So we have an agreed recommendation.
Well, no. Are you waiving the other allegation?
Yes, we'll waive and abandon the remaining allegations.
No objection.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison? And up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? I'm sorry?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, our proposed agreement is to grant the motion to revoke, adjudicate her guilty and put it into 2 years to.
That's our understanding of the agreed recommendation.
All right. And are you all in agreement with that?
Yes.
All right. Are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal? And that is why everyone, I check the boxes. I don't have other people checking boxes because I get to decide whether or not you have the right to appeal.
Sorry, Judge.
It's okay. All right. The court is going to follow your agreement. The court will grant the motion, find you guilty, revoke. Court will sentence you to 2 years in the prison, give you credit for any time served. Court will recommend the therapeutic community. Therapeutic community doesn't increase the time that you're in custody. It's really designed to help you with any addictions you may have or mental health issues that you may have. There's to be no residing in households with minors and no unsupervised contact with minors. And just let me see something here. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right. Because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. We can go off the record. Here's the thing. You got to make better choices, okay?
Yes, ma'am.
When you're released from custody, there are plenty of places that will take you in. I would suggest humbly that you try to get into lifetime recovery because they will handle dual diagnosis, or, and the alternative, if you go to felony drug court will give you different resources. Okay.
Yes, ma'am.
All right. Good luck to you. All right.
Thank you, ma'am.
You're welcome. Have a good one. Thank you. You too. All right. And Norma, are the people I'm supposed to swear in here yet?
They're still waiting for family members to arrive, so they're outside the front.
All right. Renee, did you need to speak to me about?
Yes, Your Honor.
Yes. Yes. Yes.
Regarding Juan Jordan, he's the one who we have a spot for him at Lifetime GPS. I'm requesting GPS through the work release. Just so we can expedite. I know you wanted a tracking only, so I put there tracking only.
Yeah, I guess you're.
Thank you.
Thank you. Thanks for your patience.
Of course.
All right. Who is here on Antonio Carrizales? Corrales? I keep trying to add extra syllables. Corrales. Keep adding a lot of syllables. All right, court is calling 2025 CR 011456, State versus Antonio Valentin Corrales. Could I have the parties announced for the record?
Ron Espinoza for the state.
Carl Alexander for Mr. Corrales.
And are you Mr. Corrales?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
To the best of my knowledge, the state has complied with 3914 judge, and yes, I have reviewed the evidence of my client.
Ms. Corrales, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am. I reviewed it.
Did you review the true bill of indictment with your attorney? Did you understand it?
Understood.
Counsel, do you waive the reading?
Yes, Your Honor.
Are you proceeding as on the indictment as presented? Yes, you are.
Okay, yes, Judge.
Ms. Corrales, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I signed.
You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
I agree.
Did you understand, if the court grants your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so. I will add, he was evaluated for competency. Mr. Corrales is intellectually disabled. We did have a judicial determination that he is competent to stand trial.
Okay. And do you believe he was sane at the time of the offense?
I believe he, yes, meets the legal definition to have been sane at the time of the offense. Yes, Your Honor.
Mr. Morales, has anyone threatened you or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than your plea bargain agreement that you've reached?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, I'm satisfied.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
I understand that.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I read it all. I understand it, ma'am.
According to the plea, there's a $1,000 fine, affirmative finding of deadly weapon. State recommends deferred adjudication. They're taking in consideration 2025 AL 003247. Did you understand that to be your plea?
Understood.
Defense and state?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Understand.
Any such motions?
There were only bond motions, Judge, so.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 10 years. There be a TAP evaluation, 200 hours of community service restitution, the mixed supervision, no possession of firearms, MRT, and the hostility management course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, state offers states exhibit 1 and all attachments.
Excuse me, we have reviewed the same, no objections.
All right, did you review the waiver and stipulations with your attorney? Oh, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
I understand that.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, and I do have a few items to address before the.
Yes.
So first and foremost, I guess I had been dealing with Ms. Galloway. She's not present. I did submit these documents to her earlier, but I'd like the court to consider them. So they've been marked as Defendant's Exhibit 1 and Defendant's Exhibit 2. Defendant's Exhibit 1 is a disability determination explanation that was used in ascertaining whether or not Mr. Corrales qualified as being disabled for purposes of Social Security disability insurance. And then State's Exhibit 2 is that actual determination as well, showing that he has been, in fact, labeled as disabled by the U.S. government. As I mentioned before, and which you'll find in those, is Mr. Corrales is intellectually disabled. He's also been diagnosed as schizophrenic, as well as suffering from ADHD. There were a couple of items I did want to address in the STIPs, and the court deciding whether or not to go along with the plea bargain, number one, but also in how long the probation would be for. And that's where Ms. Galloway and I kind of were at an impasse, is how long the term should be. We're asking for something less. The state is asking for the maximum period of supervision possible. We're asking for something less. This is not an instance in which we have a thug who just runs around shooting people. Mr. Corrales, because of his disabilities, does not have the same ability to engage in decision-making that you or I have. In fact, his parents, who are present here, actually have been awarded guardianship over him by a court. When Mr. Corrales turned 18, he was residing in the state of Utah. Courts there felt that he could not take care of himself or make decisions for himself, and therefore his parents were appointed guardians over his person and estate. They went on a vacation and left him alone when this happened. They are committed to supervising him, making sure that he succeeds. They have been monitoring him ever since he has been out on bond for this. They are the ones that actually retained my services, as Mr. Corrales himself really only has his Social Security income that he gets. So actually, I'm going to ask you to probate the fine as well. But in the reports, Judge, there's some things that I think on paper look bad that bear explanation. One, Antonio, as a young man, actually managed to become an Eagle Scout. He did engage in shooting sports, and one of the things he was taught to do, and that's ingrained in him, is that you pick up your brass. I know the detective went out of his way to point out about how Antonio picked up the shell casing. So that explains that. The detective also writes that Antonio walked out of the location. Discussing that with Ms. Galloway, and she agrees with me. The video shows a different story. And it's talked about a little bit in the press guide. A witness by the name of Michael actually engaged in a physical altercation with Antonio. And it was Michael that forced Antonio to leave. So it wasn't that it was a cold-hearted, just I shot someone and I'm departing. Antonio was forced to leave, Judge. And so I think that makes a difference when we're evaluating cases like this. Right? Antonio needs help. He needs to be in the MIC unit. He needs supervision. He needs the kind of help that unit can provide and that his parents are committed to helping him with. The court may remember during the pendency of this case, he was also hospitalized for his mental health and actually missed court, and we had to provide proof of that. He has had some suicide attempts in the past. He has engaged in some self-harm, and a lot of that is actually talked about in the narrative portion of Defendant's Exhibit 1. My concern with what the state wants with 10 years of deferred is that long of a period with a young man who has the deficits that Antonio has, is we are exponentially increasing the likelihood that he will mess up on some sort of technicality. The court can certainly extend him if he has a minor violation. And obviously, and I had to explain it to him a few times, but he understands that if he were to violate, the court also has the full range of punishment if the court chooses to revoke the deferred adjudication. but we're asking that you at least start him off somewhere on the lower end of 3 to 5 years, which I think is certainly enough time to see how he does, to see if he is rehabilitated, if he has learned from what he did. And if he needs a little more time, then the court, of course, can always extend him up to the 10 years. But I think the 10 years, when you look at the totality of who he is and how this all came to be, I think 10 years is excessive.
All right. I'm gonna allow defense counsel to withdraw defense exhibits 1 and 2.
Thank
And
you,
if
Your Honor.
you'll give those to probation.
Sure.
This is what the court is gonna do. Court is gonna sentence you to $1,000 fine that will be probated. Regular reporting by Zoom or in person, regular random UAs. Is he going to remain in San Antonio?
I believe so.
Yes,
Yes,
ma'am.
yes, his parents are nodding yes.
All right, taking consideration 2025 AL 003247, 6 years deferred adjudication, no contact with the complainant, no possession of firearms or ammunition. There'll be a referral to Center for Healthcare Services, the Mental Health Initiative, 200 hours community service restitution. Once he's completed hostility management course, 100 hours will be deducted. The remaining 100 hours will be deducted upon completion of the MRT. Proof of SSI or proof of employment within 45 days. No employment as a home health care provider with minors. Are there any minors living in the household?
I don't believe so.
No.
Yeah, okay. There's to be no unsupervised contact with minors. No residing in households with minors. No contact with the Waterburger that's located at 8002 Fredericksburg Road. And field visits 1 time per month for 8 months. Probation, is there anything else?
No, good.
All right, is there anything else that you need from the court to be successful?
Just, I wanna be an electrician, so I wanna go to school.
Okay,
Let's finish your probation first. Okay.
Judge, mental health will make supervision or no?
yes, mixed supervision. All right, and I'm sorry, there's an affirmative finding of deadly weapon.
Yes, ma'am.
All right, to the parents, is there anything else he needs or they feel he needs?
Feel good?
All right. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understand.
All right, we can go off the record. Here's the thing. Whenever there are disagreements between people, when you see it's ramping up or escalating, just walk away. In the words of my grandmother, you know what she would always do? She'd walk away and she'd say, somebody got to have sense. And so she'd just walk away. So in your mind, you can say, somebody got to have sense and just walk away. Okay? All right, good luck to you.
Thank you.
You're welcome. Thank you for dressing appropriately for court. You always do, though. I appreciate that.
I appreciate it.
All right, thank you.
Thank you, Judge. You may be excused.
Yes. Anyone else ready?
No, yes, I have a report.
Robert?
Page 3, 1 down.
All right. Pabler? Hello. I see it's acting as though it's doing dial-up. All right, so outstanding ballistics stuff.
No, me and Miss Galloway have been fighting all afternoon. She finally made us an offer. I know today was a final offer date, but she just made the offer.
Oh, no. Actually, on here, I have it, the outstanding ballistics, but y'all have all.
We have everything, Judge.
Okay. Oh, you know what? It's probably listed on.
When the other one she's got.
Yeah.
This courtroom hearing starts like a normal plea deal, but quickly turns into one of the most emotional and uncomfortable sentencing moments imaginable. A 21-year-old man stands before the judge facing robbery charges involving a hotel setup, stolen property, and a firearm. At first, his attorney argues that despite everything, he still deserves one chance at probation instead of prison. Then, the hearing takes a deeply personal turn. The defendant's mother testifies about the trauma her son suffered growing up: abuse, instability, violence, and years of emotional damage that she says completely shaped the person he became. She tells the court her son is intelligent, capable of changing, and now motivated by one thing more than anything else: his 2 young children. "I just want my son to have a future." But prosecutors aren't convinced. They begin pressing both the mother and the defendant with difficult questions about firearms, hotel robberies, missing court appearances, and whether he truly changed or simply learned how to say the right things. Then comes one of the strangest moments of the hearing. When the judge asks the defendant why he deserves another chance, he starts speaking in long philosophical answers about evolution, character, and changing internally. The courtroom almost struggles to understand whether he's genuinely remorseful or avoiding direct accountability. But then, the judge finally cuts through everything and focuses on the real issue. Why are people continuing to have children when they don't even have their life together? The courtroom falls silent. The judge then reviews the allegations in detail: a planned robbery, a firearm pulled on the victim, threats involving a gold chain, and evidence suggesting the entire setup may have been organized ahead of time. And suddenly, this stops feeling like a young man who simply made one mistake. Now the judge has to decide something difficult. Is this a dangerous person manipulating the system, or a broken 21-year-old who still has time to completely change his future? So here's the real question. Should courts give young offenders like this one last opportunity through probation, or do violent allegations involving guns automatically deserve prison time? Like and subscribe for more real courtroom moments.